Hi, everyone. Welcome to today's webinar. I see that we still have people joining, so I'll give everyone a minute to get signed on. I'm Nicole with the San Diego Law Library, and I have here with me today our speaker, Kimberly Sims, who will be discussing Cannabis Law 2025-2026, legislative updates, challenges, and federal outlook. I just have a couple of housekeeping things to do before we get started. First, you should have already received the handout for today's webinar. If you haven't received the handout for today's class, please email refdesk@sdlawlibrary.org and we'll resend the handout. Again, that's refdesk@sdlawlibrary.org. You can also find that email on our website. Next, for those of you who are here for CLE credit, this is a class for 1 hour of general participatory MCLE credit. We'll be issuing a participatory MCLE certificate for any of you who have been verified to have attended today's class. So be looking for that in your email later this afternoon. And as a reminder, always check your spam and junk folders as well for that email. If you're attending today's class via audio and dialed in using a phone number, please send us an email with your name, phone number, and bar number in order to receive a MCLE certificate. Again, that's only if you're using dial-in and a phone. You'll need to email us your name, phone number, and bar number. For those of you who are watching live on Zoom today, if you'd like closed captioning, there is an icon at the bottom of your screen with letters CC. Once you click the icon, the closed captioning will appear. This is also an interactive presentation, so you'll have the opportunity to submit questions to our speaker during the presentation, but we do ask that you use the Q&A function for that. And under the Q&A function, you may ask questions either anonymously or with your name, whatever you feel comfortable with, and we'll try to get to as many as we can. Lastly, you'll receive a link to a survey at the end of the presentation. We really would appreciate any of you who would take the time to fill out that survey and give us some feedback on today's presentation. And with that, I will turn things over to our speaker, Kimberly Sims.
Thank you so much. And thank you everyone for joining me on one of the first sunny days we've had in many, many days. My name is Kimberly Sims, and I am a corporate and transactional attorney with a specialization in the marijuana and hemp industry. I have been doing this work for close to 16 years now. And in the cannabis world, that's like dog years. So I'm basically ancient. I've seen so many changes over the last 15 or 16 years with respect to the cannabis industry, and it continues to change constantly. So I'm so honored to be here. The Law Library asks me to come each year and give an update. And before I dive in, I guess I would say that any one of these slides could be its own presentation unto itself. And so, and Nicole, if you can just click to the overview, the next slide, the overview slide. I'm treating this a bit more as like a foundational session. There's really, unfortunately, not time to deep dive every single issue. So my goal is to give you a strong overview and explain what's going on federally. I find each year that that is where people are most interested, to talk a little bit about what's going on in California, some of the tax issues and issues that are causing instability in the market, and then just spend a few moments giving you my Oracle magic 8 ball vision of what is to come. So again, in a lot of these slides, I'm just going to spend a minute on, but I know you guys do get a printout of them. And so the market update, I'm just going to breeze through, but folks usually do find it super interesting. So I like to include that. And I will do my very best to keep track of time and make sure that there's time for Q&A at the end. I do have the ability to stay over a little bit if you guys do, and you can always email me as well. My information is on the final slide. If we don't get a chance to cover your question, I'm always happy to jump in. A large part of my practice is actually being brought on by other attorneys that have cannabis touching their practice somehow in some way, but it's just not their focus, but it touches the matter at hand. And so I can jump in and be part of the team in that way as well. So next slide, please. Again, just a quick little market overview here. Marijuana is now legal in 42 states plus Washington, D.C. And California is the most mature market, which means that we're looking more at enforcement and less towards regulatory grace, I guess you could say, by the Department of Cannabis Control, which we'll talk a little bit more about later. Next slide, please. So I always love to give the sales forecast, and you could see that it goes up each year. But what is actually really interesting is that the market itself is contracting. So we see that by looks like 2026 that there's expected to reach 47 billion, with an estimated growth rate of about 3.36%. And what we really see is that as the market is consolidating, the price of flour is dropping, but competitive pricing is trending among brands and retailers, and that has led to a significant decline. And why I mentioned the contraction of the market, especially here in California, what we're seeing is when we started licensing in 2018, we had really, and still today, not enough retailers to offset the amount of cultivation that we've had. And so what has happened too to a lot of the smaller mom and pop retailers is they're being bought out by larger companies. And so now you have probably ten companies, 10 brands that control the majority of the market. And obviously, the more you buy wholesale, the better pricing you can get. And so it's allowing these top 10 or so retailers with, half a dozen stores to ultimately lower their prices. And so that is ultimately what's going on, even though the price of flour is dropping, which one would ultimately think um, would also make it easier for more people to come in and buy product, but that's not really ultimately working out that way. So what we see is that even though there's been this like a gradual decline in the national aggregate flour price, ultimately we still see compressed margins. So it looks good on the slide, but ultimately it's continuing to be very difficult to turn a profit in this industry. Next slide, please. Just a quick little little slide here. I want to point out that beverages is the one category that seems to stand out for its growth trajectory. And it looks like, according to Headset, which is one of the leading cannabis data companies uh, in cannabis, they say that beverages accounted for 7.8 million sales just in January, with an average item price of $7.53, which is markedly lower than all the other categories. So I think that that probably has something to do with it. Um, and I think that that also makes it a little bit easier for new consumers to come in, right? Like nobody wants to go and spend 50 or $60 on something that they may not ultimately like, but $7 or $8, not so bad. So again, you can see that ultimately flowers and vape pens are still dominating, but we do have interesting growth in the beverage market. And I think that that will continue to be the case in this next year. Next slide. Okay. So again, licensing trends here. Cannabis businesses, their licenses have steadily been declining for the past 2 years. Although, of course, the pace varies by license category. The decline in cultivation licenses is probably the most challenging, but also positive development because, again, as I mentioned before, at least in California, we had far too many cultivators growing cannabis compared to how many retail outlets we ultimately had. So at the end of the third quarter, there looks like there were about 16,000 active cultivation licenses in the US compared to roughly 11,600 retail dispensaries. What is interesting, and I think it would be interesting to do a CLE on the way that Canada's market is laid out. But by contrast, and so again, this slide also is intended to show the contrast. Canada's market is more weighted towards the retailer, right? And so that country has like a 4-to-1 ratio for cultivation licenses and more than 4,000 retail licenses. And there's like just under 1,000 cultivation licenses. So how we license matters in terms of pricing, competition, and market. So that's my little market update. Next slide, please. Again, more just for the curious. It's not necessarily legal, but I do think it frames a lot of what we're going to talk about. So one cannot begin any sort of CLE on cannabis without acknowledging that it still remains illegal. The Controlled Substance Act dates all the way back to the 1970s, and it pretty much drives everything else that follows from here. And we we have five separate schedules here in the great US, and those schedules are largely defined based on, I guess we can go to the next slide, please, on the safety and the perceived risk. So schedules are about perceived risk and medical use, and marijuana, where it sits on this, it is a legal distinction, but not practical. So you can see that marijuana at present is listed as a Schedule 1 drug, which means there's no accepted medical use and a high abuse potential. And it's sitting next to things like heroin and LSD. And based on its federal illegality, it makes it really hard to advance research on its efficacy. So the big thing that happened at the end of next year, next slide, please, was that Trump issued an executive order on December 18th to direct the various departments, including the Department of Justice, to complete rescheduling of marijuana to Schedule 3. And this is a really interesting moment in the history of cannabis because I think that we have to acknowledge that it is, the most significant shift we've seen in 50 years. Um, and it is a formal acknowledgement of medical use at the federal level, which is hugely important, right? Because we have medical marijuana and recreational marijuana, or adult use, as I like to say. And what I do want to point out is that, this executive order, again, a lot of people were applauding it, you know, opinions aside about Trump and his policies, the marijuana industry was obviously very happy about this, but it didn't start the rescheduling conversation. What it did is it formalized a process that actually began under the Biden administration in 2022 and 2023 when federal agencies were directed to review the Schedule 1 status. And that review ultimately reflected a growing acknowledgement of medical use and this like disconnect between widespread state legalization and the federal law. So the rescheduling process started to move forward, but ultimately, and I believe I talk a lot about this in last year's CLE. So if you're interested in that, maybe look for that on Law Library, their YouTube channel, or reach out to me. But what happened was the process started, but it was paused due to procedural and administrative law issues. One of which was that there were allegations that the Department of Justice was heavily favoring comments and testimony from anti-marijuana legalization groups. So the administrative law judge at that time basically paused and ordered different briefings and things like that. So that is why that halted at the end of 2024. Then you fast forward to the end of 2025, and this EO basically restarts and directs completion of the process under the Controlled Substance Act. So, again, what is, I think, most important, next slide, please, to acknowledge is that ultimately, this is not legalization. An executive order doesn't change the status, it just kind of triggers the process to begin again. And there's a lot of disagreement in the marijuana industry as well as to whether this is good enough. Is Schedule 3 good enough? What does it do and what does it not do? I myself believe that what we ultimately need is for marijuana to be removed from the schedules altogether and treated as we do alcohol. That said, I do acknowledge that a move to Schedule 3 would certainly be helpful, but it's not, for me, it's not end game. So what does it do? What if we can get all these departments to come together and do what they're supposed to do? The practical impact would be, um, you know, as I mentioned earlier, it would hopefully start to end the stigma that cannabis has and fully recognize the medical benefits. It would most certainly improve research and access to cannabis. And part of the directive was also to look at CBD and hemp and create a better definition for full spectrum CBD and see how that could even potentially be covered under insurance. So I think that's super important. And I think the most practical impact that it would have for the businesses is that it would end to the application of 280E, IRS tax code 280E. And I'm not a tax attorney, but what I can tell you, quickly here is that 280E is incredibly prohibitive for our industry. Basically, what it says is that if someone is trafficking in a controlled substance, Schedule 1 or 2, then they're not entitled to any standard or ordinary business deductions. So, like, that makes sense, if you're dealing in cocaine. Sure, you don't get to like deduct your baggies and your scales. But you have this industry here that is recognized at the state level and it's still being taxed at a rate that is much higher than any other business. And that, again, compresses margins. It reduce, if you don't have cash flow, it impacts your entire business. And so the cannabis industry is taxed at a much higher rate than any other industry. But again, this is not federal legalization. The state cannabis programs will still control. And we still have all sorts of other types of legal consequences that will flow from it still technically being federally illegal. So banking barriers will still exist. So access to traditional capital is very challenging for the marijuana industry. There would still be immigration consequences. There are actually a lot of interesting things happening in the at the Supreme Court level with respect to gun rights. So that's something to keep an eye on if you are curious. And most importantly, I think, which is ultimately what I believe will allow the industry to truly flourish, is that Schedule 3 does not open interstate commerce. So again, expansion then becomes incredibly difficult. So, I think that it's a step forward, certainly, and there are some important impacts, like again, the elimination of 280E, as well as, as well as some of the other um, uh, research things that would ultimately become available. But it is not full stop. It doesn't get us the whole way through. Next slide, which I think is actually possibly misplaced. So actually, let's skip this and then let's note Nicole slide 11. We'll come back to at the end because that is not supposed to be there. So the next thing I want to just again touch upon, and this truly, truly could be a whole other seminar. Hemp and marijuana, they're the same plant. The legal difference is based on THC content, not biology, obviously, as we're seeing, and it's treated very differently. And it has to do again with how much THC. So zero point 0.3 or less, hemp, zero point 0.3 or more, marijuana, but ultimately it is the same plant. And this distinction ultimately impacts how it can move through supply chains, interstate commerce, banking, and there are different rules for testing and enforcement and things of that nature. So when you are dealing with the clients here, you do need to make sure you know which they're talking about because there are some other things that so the 28 I guess we can go to the next slide. The 2018 Farm Bill created a lot of loopholes because it more or less allowed for intoxicating hemp products to be able to be sold nationwide. So the way that you can like marijuana and hemp are made up of hundreds and thousands of different, well, maybe just hundreds of cannabinoids, which includes Delta 9 THC, which is what we are most familiar with. That's the psychoactive component of marijuana that makes people feel high. And then you have CBD as well. Delta 8 THC is found in the hemp plant, but it's incredibly similar to Delta 9. And so basically the Farm Bill legalized hemp and any hemp derived products, including Delta 8. And so now what you are starting to see is that these products are popping up everywhere, but they are not held to the same standard as a marijuana product. Because ultimately, one, you can walk into any convenience store and buy them. Two, they're not being tested in the appropriate way. And they're not there's no age gate there. So there has been a huge proliferation of these Delta 8 products. And it's this farm bill that ultimately like created this whole loophole. And the products are confusing to people who aren't in the industry, right? They're walking in and they're thinking it's a hemp product, but again, it doesn't have the same testing. It doesn't have age restrictions. There's not very much oversight either. So basically, late 2025 is when the federal government stepped in, and I don't think that's wrong. I think if you have an intoxicating product, it absolutely needs to be regulated. So the government stepped in, and the goal, isn't necessarily to either legalize or ban hemp outright, but to narrow what qualifies as lawful hemp and bring a lot more consistency here. So I think what I would say is for lawyers who might be interested in this space, hemp is not really like the low risk alternative that it once seemed to be. The marijuana industry is very difficult to get into, but people thought, oh, hemp is easier. It's not federally illegal. I can sell it across state lines. I can sell it anywhere. I can sell it on Amazon. But that now has to be fully reassessed based on this farm bill. And this November 12th action, sorry, I skipped ahead, was basically directing the federal government to step in and rein this all in. Um, and we'll come in a few minutes, I'll talk as well about California's specific response to that. But that's sort of the federal overview. It's what's going on. The thing that people, I think, are most interested in is ultimately this Schedule 3 process. And a lot of folks often ask me, do you think that's going to happen soon? Do you think there will be challenges to this? One, I don't think it's going to happen soon. Since the memo was issued, we haven't seen any scheduling. It hasn't been put on any dockets. That it's like the executive order happened, everyone got excited and reacted, and now it's just sort of like a wait and see. Um, and I absolutely believe that there will be challenges to it as well. But there's several steps that still need to happen for before a final rule gets implemented and it's moved. And there's also a lot of talk. I don't know if we have any CPAs or tax attorneys on here, but there's a lot of varying opinions about when 280E will go away. Some people, I think, are putting on rose-colored glasses and think that it'll ultimately be retroactive and people will be able to amend their taxes. But never have I ever seen something where the IRS like readily just gives money back to people. Some people say they're going to stop with the 280E deductions right now. I think that is a very risky gamble. Ultimately, it is my opinion that the trigger is when the final rule is published and it is effectively moved to Schedule 3. But there's a lot of discussion going on about the, who, what, where, when, and how of 280E, because again, that is the most helpful thing for industry with respect to the rescheduling. Okay, so next slide, please. So now I'm just going to reground all of us in California, and we already talked about the federal rescheduling, and now we'll talk about California's system that controls the day to day. So, excuse me, the marijuana industry in California is governed by the Medical and Adult Use of Cannabis Regulation and Safety Act, or we call it MALCRSA, and it allows the Department of Cannabis Control to be the primary licensing and enforcement agency. But the most important thing, and I cannot state this enough, is that local control is preserved. There is no state license to apply for unless and until you have received full authorization from your local municipality or your county. And each and every city and county in the state of California gets to make up their own rules. So in the beginning, you had very few cities that were allowing licenses. Not surprisingly, San Francisco was one of the first, Oakland, but San Diego actually came in fairly early too, and they approached licensing marijuana. They started just with retailers, and later, few years later, added the different license types, but as a straight land use process. So in California, or excuse me, in San Diego, if you want to be a marijuana operator, you go through a conditional use permit process and a background check. But you don't have to have had experience in it in the industry. It's a straight land use. And I always joke that hindsight's 2020 because I remember when this originally happened and a lot of people were like, that's ridiculous. Like this process is too cumbersome. It's going to take like a year to get through all the hearings and commissions, and you have to pay rent on these spaces, and it's just not fair. It's not a good process. But what has ultimately happened is most cities have moved to either lotteries or merit-based or some sort of hybrid of both. And those are far more arduous and competitive. For San Diego, it was kind of just like, did you get your application in on time? And there was lots of lines down the streets and fodder about people paying people to wait in lines. But now you really have a very slim chance of getting a license if you don't already have one, because so much of that merit-based application often is your experience. And sometimes they'll wait having someone with X amount of years in the cannabis space. So getting a local license is not an easy process. And each and every city gets to decide how they want to approach it. And that also includes nothing at all. So you still have many, many cities and counties that have full stop bans and are what we consider cannabis deserts. So um, that is one of the challenges. So local control is, I think, the most critical cornerstone of the state regulations, and understanding what your city does and does not allow, not only with respect to the application process, but in terms of transferring ownership and relocations and things like that, because each city, again, has their own rules on that. Next slide. Okay, this is a quickie here, not much to say. I just wanted to point out, again, it's the Department of Cannabis Control that governs all of this. At the state level, obviously, as I just said, you first apply at the local level for the type of license you want, and then you move up to the state level. And as I also mentioned, it's not, the ratios of cultivation to retail aren't where we want them to be quite yet. And you do have a lot of cities that have come on board with the manufacturing or distribution or testing or cultivators, but maybe not so much retailers. So we don't need to spend a ton of time here. I just thought it was important to point out the different license types. And within retailers, you also have delivery only. Next slide. Same thing. It's just a quick snapshot of what's going on in California. And I do want to point out the Department of Cannabis Control has a wonderful and robust website where you can search, all the regulations. You can access the licensing portals, Q&As, updates, and then they have a data dashboard and a search tool. So if you need to look for a license, or you're, you know, a data nerd and you're interested more about, what type of licenses there are and how many, you would want to go to the DCC website, and then there's a data tool portion, and that's where I snapped this from. Um, but again, it's contraction from last year as well. So again, we don't need to spend a ton of time here, but I do like to, point out it's a good way for me to tell people about the website and what types of tools you can find there. So next slide, please. Thank you. So again, don't necessarily want to spend a whole bunch of time here because I want to get into some of the more nuanced discussions and leave time for Q&A, but it's important to understand the steps needed to obtain a license. And so again, you get your local license first, and then you ultimately will apply at the state level. And there are really stringent disclosures for ownership. There's really no such thing as a silent partner anymore. And in a few minutes, we'll have a slide on who counts as an owner, because when I think of owner, traditionally I think of someone that has equity in a business, not as someone who just controls the day-to-day business. But in cannabis, we have equity owners, but we also have what I call regulatory owners. So it's important to understand who your owners are. You'll have to, of course, disclose all of your corporate documents as well. And then there are, other compliance things to look at. CEQA compliance is huge, not so hard for retailers. It's much more difficult on outdoor cultivation for obvious reasons. You do need to submit your standard operating procedures. You have to have a landlord that is willing to play ball, because they also have to sign some documents and some authorizations. And I often put just a little practice tip when I'm drafting a lease for either landlord or tenant. I always put in a clause that talks about landlord's ongoing cooperation and making sure that the landlord knows and acknowledges that these are forms that need to be filled out and that without them, the uh, lessee cannot obtain a lease. And so you want to have something in there that requires ongoing cooperation, obviously given reasonable timelines and things of that nature, but it is required. You have to have a very detailed premises diagram. Most people will hire an architect to help with that. Um, there also is the unions play a big part in the marijuana industry and are largely helpful for the passage of Prop 64, which is what kicked off the adult use in California. Um, if you have 10 or more employees, you must enter into a labor peace agreement, and then you have to resubmit your LPA each year at your annual renewal as well. And then you have licensing fees that are, of course, based on size and gross revenue. And then there are a lot of restrictions on the transfers of licenses at the state and the local level. So, you know, I don't necessarily mean for this to be like an instructional checklist, but it's more of like a structural cost burden. Um, Although it does often feel like an administrative task list. And, I often have to remind clients, I can't fully submit your application to the state until you have your premises diagram, and you can't operate until you submit your license and pay the fees. So it's important to stay on top of clients because it's a lot to gather. Um, and like any government portal, it's finicky and does its own thing oftentimes. So you want to make sure, again, that you're making sure that the client, the applicant knows what they need to do and how you're going to help facilitate getting through those regulatory barriers. Next slide. Okay, so who is an owner? And this is governed by Section 15003 of the regulations. And so I mentioned, what we talked about before, which is an equity interest. So here it's capped at if you have more than 20% of a business, then you are considered an owner. But what really gets people, and again, I have, mixed thoughts on this, is that a regulatory owner is anyone who manages, directs, or controls the operation. And that can be, but it's not limited to, a member of the board of directors, a general partner, a non-member manager, um, a trustee. I haven't actually seen that happen necessarily. In a while, but there was a time when you had to also disclose um, any of the beneficiaries as well. And so, like, we were disclosing, like, 7-year-old Janet to the DCC, not as an owner, but they still were asking who all the beneficiaries what were. And then, of course, any officer position. And it is a subjective analysis. The DCC is not going to tell you, yes, this person qualifies as an owner. So I always err on the side of caution, and I have an internal checklist that we go through, like, does this person have the ability to sign contracts? Does this person have the ability to hire and fire? Does this person have the ability to indebt the company? So there's all sorts of things. And again, ultimately, it is a judgment call on behalf of the applicant. But you also have a lot of companies that um, will have a management company come in. So again, one of the ways that some of the I mentioned earlier that you've got like 10 or so brands that are ultimately leading the way and they're buying up a lot of these smaller companies. Part of what they're doing, one of the structures that they'll do it is they'll take ABC Inc. located in X city, and then they'll enter into a licensing and management agreement to run the store with the brand's name. And so then that company also becomes an owner and they have to be disclosed as well. And it's like the nesting dolls for owners. The DCC wants to get down to the individual person. So if you have an entity that is owned by other entities, and within those entities, other entities, you have to get down to the individual. So that's why I mentioned, like, there's really no such thing as a private owner. A lot of people thought originally that they could hide behind entities, but for ownership, that is not the case. You have to be comfortable, getting your live scan and the background check and all the things that are required of an owner, whether it's equity or regulatory. Um, Next slide, actually, which is exactly what ownership disclosures are. So again, I guess I got ahead of myself and I said all the things that were already on this slide here. But again, that multi-layered entities doesn't excuse the requirement. And again, I call that the nesting doll rule. And I have had overseas investors ultimately back out because they did not want to be listed in that way. So I think it's really important when you're dealing with clients to make sure that they fully understand. I interestingly, I did a CLE last week that talked about how cannabis businesses impact family law. And that topic came up quite a bit as well, in terms of parties not necessarily wanting to be owners because they don't necessarily want their spouse to find out. So again, that cannot happen here, and it's not like a trivial rule. The department wants to know. Okay, next slide. So same thing here. Financial interest is another, term of art that we have, a financial interest holder. And so there's a lot that gets triggered here. A person with an aggregate ownership of less than 20%, obviously. Someone that loans money to a cannabis business. So I've had a lot of lenders, hard money lenders ultimately back out because they're not interested in being listed. And then you have a person that's entitled to receive 10% or more of the profits. If you have a landlord with a profit share, they might need to be disclosed. Depending on, an IP licensing agreement might trigger that requirement as well. That's a bit more of a complicated analysis because many manufacturers are white labeling for lots of different companies. So you have to ultimately kind of figure out what percentage of your business that is. Um, but the one thing I think that is important to note here as well is that the nesting rule doesn't apply here. So if you have a financial interest, you can certainly just list the company and the company EIN, and that is sufficient for financial interest disclosure. And every year renewal, you are asked, are the financial interest holders still the same? And you have to again then go back to your client and say, did you take any money? Where did you take it from? What does that look like? And explore, under the hood, the different financial arrangements that the business has so that you can ensure you're making the right disclosures or at least guiding them on such. Next slide, please. Okay, so this is another fun one that could ultimately be a whole long presentation unto itself. Um, Licenses are privileges, not property rights. So they are not transferable in the way that a typical business attorney would approach either a stock purchase agreement or an asset sale. The first thing you have to look at is what do your local rules say about transferability? So we'll use San Diego again as another example. San Diego is fairly simple. The new owner just needs to go get a background check and off they go. Then they have this like operator's permit because remember the main permit, so to speak, is that conditional use permit. It runs with the land. It's not really about the person. But you can contrast that to the city of Corona and Riverside, for example, which says that at no time can the original owners transfer more than 49% of the business. And that can't happen until the business has been operational for a year. So when you're thinking about the purchase or the city of Los Angeles is another really great example. They have all these different types of licensees, and they have a very robust social equity program, and different tiers for social equity holders. But that's one where if you are what's called a tier one social equity license, you can never transfer your 51%. And that it leads to a whole host of issues because one, what if that social equity person wants to sell the business? Well, they can't ever sell more than 49%. That's problematic. I had a client several years ago wherein the social equity applicant, is what we call them, said, I want to dilute below 51%. The company needs money, and frankly, it's not going to stay afloat unless we can bring in some investors, and they obviously want a piece of the pie. And ultimately, that business went out of business because they couldn't dilute enough to make it worth the investment. So I sometimes call LA like the golden handcuff rule. All this is to say, it's really important that you look at the local rules first because the last thing you want to do is draft a stock purchase agreement for 100% of equity only to find out, oh, wow, this company could never have done that. They weren't allowed to do that based on the local regulations. And so, again, there are drafting things we can do like rights of first refusal or options. For nominal amounts of money if and when regulations change, and you want to build all of that into your agreements as well. Then the other thing you want to, of course, look at is what the state says. And the state also has some rules. If you're interested in looking, it's 150023 that ultimately it's a large section that talks about what types of notifications require prior approval from the department. And one of them is that if you, we call it the 80/20 rule. So it varies from analyst to analyst how they deal with it, but oftentimes what it says is that, or oftentimes what the rule says is that if you are not going to have continuity of ownership, right now, ownership we know is either that 20% threshold or that oversight in by way of non-managing member or officer or board member, and ultimately that remaining one person in that role isn't staying on, then you have to do the application all over again. So you don't end up with continuity of operations. And no, the whole point of buying a business in theory is that you step into something that's ready to make money. So what you see a lot of times is that they'll bifurcate the sale. They'll sell 80% first, and then later down the road, 20%. Or what we prefer to do is to keep on one of the original parties as a manager or an officer, and then we obviously want to indemnify them and protect them in all the necessary ways, um, and keep them involved until such a time that they can then be removed. But the analysts they're all a little bit different. Sometimes keeping an original owner on with 100% sale of the company, but we keep original owner on as the vice chair of the board. Um, Sometimes the analysts are okay with that and they'll approve that, but other times not. So you also want to have a provision in any sort of contract that talks about um, amending the contract to meet any sort of regulatory burden as is necessary while keeping the other terms intact. And then you do have to notify the Department of Cannabis Control and local as well of the changes of ownership. And then you also want to, and I think this is true of, I know this is true of any business, you do want to do an asset versus equity analysis. But here, I think what becomes really critical to look at is any tax liabilities because again, this is an industry that's struggling greatly, and there is a state excise tax of 15% that needs to be remitted by retailers, and a lot of these businesses are really struggling. And so while it would be simple enough to say, well, why are you not just setting that aside? It's sort of like a pay Peter to pay Paul situation. They're always scrambling. And what we're starting to see is that CDTFA will revoke your seller's permit for failure to pay your sales tax or your excise tax. And if you don't have a seller's permit, you're no longer eligible at the state level. So we're starting to see the CDTFA come in and do a lot of revocation, but many, many, many of these businesses are behind on taxes. If not federal, then most certainly local and state. And so you don't want to ultimately inherit tax liabilities. But again, it goes back to those local regulations. What are they going to allow you to do and not do? And that will ultimately be the first step in driving the analysis of how you structure everything. So this is where things get kind of tricky, and we're having an experienced attorney draft these transactions because I would say at least a few times a year, something comes across my desk that someone who wasn't familiar with all of this has structured, and they've sold something they could not ultimately sell. And that obviously creates a lot of problems and headaches. So this is an important one, and there's a lot of thought and nuance that goes into how we structure our cannabis transactions. Next slide. And again, I could talk forever about this one. Um, excuse me. So as I said at the beginning, California is a much more mature market, and for the first year or two, we saw a lot of grace from the regulators in allowing people to correct mistakes without penalties or violations. But we're in a new era now, wherein we're seeing many more enforcement efforts. So the DCC has the authority to issue fines, citations, suspensions, or ultimately revoke a license altogether. And then you have the UCETF, which is the California's multi-agency task force, and they are focused. So Department of Cannabis Control is focused more on compliance issues and they're going in and doing inspections. But UCETF, it's so many letters to say, is more focused on targeting the illicit market and unlicensed operations. And I think that well, I know that the proliferation of the illicit market is one of the things that is most challenging to the regulated market because they don't obviously have the same costs and taxes and exposure. And so they can sell things much cheaper. And again, when you're looking at all the various taxes that are, of course, being passed on to the consumer, it's not cost effective necessarily anymore. To you can ultimately end up with $100+ in taxes because you have whatever the local tax is, and that's most cities have a local tax, and sometimes it's at each licensing level, so it will compound. Then you have sales tax, then you have excise tax. So it's really interesting, I think, sometimes to look at some of these receipts and see how much someone paid in taxes versus how much product they actually got. And we also know that it's a struggling economy, and we know that prices of everything are increasing, but our cost of living is increasing, but our paychecks aren't necessarily. And so people are going back to the illicit market. So um, I think that this agency, the existence of this agency signals that the state is investing in enforcement. And I do have some data here that I'm going to read right off the paper so I don't mess up. But California's law enforcement reported seizing and destroying a record 377,000 pounds of illicit cannabis worth 609 million in 2025. But again, it's outpacing the illegal cultivation, quite frankly, is outpacing the regulated market. Um, and so I think it is my personal opinion that ultimately we need to see a further reduction in taxes. Interestingly enough, San Diego City has gone the opposite way. It's decided to increase the taxes. And I think that's a mistake. I would always rather get a piece of pie than no pie at all. Um, and then so that's the on the UCETF side. The most common things we're seeing at the Department of Cannabis Control side, I would say, is track and trace violations, which is our seed to sale tracking. And we see um, packaging, a lot of packaging violations as well. You can't have packaging that's attractive to children, but again, that's incredibly subjective. And then, of course, unlicensed commercial activity. So, a lot of this data too that is on this slide can be found in the on the DCC's website and that data tool as well. Next slide. Okay. So this is I guess, builds upon the enforcement slide. So we see that it's intensified, but it's not a fix, right? As I just mentioned, the illicit market is outpacing by some out counts by, tenfold. I didn't fact check that myself, but that's what's being reported. Um, the other side to that coin again is this crazy tax structure. And it's pushing people outside, it's pushing operators and customers out of that license system. So there have been some efforts at the legislative level, um, that while, hope to address this. So if we zoom out, again, California is not really in its expansion mode anymore. We're trying to stabilize things. So you don't have a lot of new people coming in, and you have a lot of distressed assets that are also being picked up by some of the larger operators. Again, enforcement has matured and it's more aggressive, but it's only one side of the coin. So we're seeing a lot of efforts from Sacramento to hopefully address that, and I'll kind of run through those quickly as well. We have AB 564. Next slide. Sorry about that. So this AB 564 is incredibly critical to the industry. There was another bill back in 2022, AB 195, that created an automatic mechanism um, to raise the excise tax, which I said was 15%, to up to 19%. And so there were a lot of groups that worked really, really hard on AB 564 to keep it at this 15% because we really can't tolerate anything more. I mean, again, it's the margins are already so slim, and it's all these things we've been talking about. It's the federal illegality, it's the 280E, it's the lack of banking and access to capital, it's the ratio of cultivation to retailers. It's all problematic. So hopefully this this signals that Sacramento understands what's going on and they're acknowledging the tax burden and tax crisis, and we'll have to continue to fight to keep that. And again, I don't think there's a world where it gets lowered, but the fact that it didn't go up was a major victory for the industry. Okay, next slide, please. So I mentioned that I would talk about what California's response was to the hemp situation. So we have back in 2024, there was emergency regulations that were put forth to regulate intoxicating hemp. Again, the big focus is obviously on this Delta 8, but there are other converted THC products out there. And so we had these emergency regulations that looked at banning intoxicating hemp from general retail, age restrictions. There were some enforcement sweeps on some of that. Um, and it's again, it was that you had people just running into any store and ingesting things they didn't know what they were, and that's never a good thing. So we had emergency regulations, but then we ultimately got AB 8, which codified that structural enforcement authority. So again, it's aimed at closing those loopholes and making sure that intoxicating cannabinoids move through the licensed dispensary, but hemp products are not allowed to be sold in dispensaries. So we still have a lot of work to do to integrate the two supply chains. And I will say there's also a lot of conflict between the hemp and marijuana industry as to how this should be handled. I personally would like to see parity between the two, um, but we're not there yet. So AB 8 again could be its own whole hour plus talk. But I just want to flag it as California's response as well. There's some packaging restrictions and things like that. But one should not be able to now walk into Circle K or Shell and buy intoxicating hemp products, hopefully. Next slide, please. Um, and then the last thing I want to flag here is SB 378, which focuses on online marketplace accountability. So you have a lot of online platforms that are basically facilitating the sales of illicit cannabis. Weed Maps is one of them. I'd say they're the largest player. And every once in a while, I like to pop onto Weed Maps and just see what's what. And you can't tell if you don't know. You don't know what you don't know. If you don't know, you need to look for a specific license number and certain markings to show that this dispensary is regulated, but this one is not. It's confusing. And so we, a couple years ago, the DCC tried to come down on weed maps, and they're not the only one. They're just the biggest player out there, and basically say you have to remove all of these unlicensed dispensaries from your marketplace. And they did for a while, but slowly but surely they've crept back in. And so we need accountability, and we need a way to level the playing field and ultimately make sure that that we deal with the friction between these platforms that are promoting the illicit market and the regulated market at the same time. So that's one I certainly will be keeping an eye on as well. And then I just have a few more slides, which actually we could go over these again really, really quickly here. We've talked about all of these things already. Um, the Department of Cannabis Control did just get a new director, Clint Kellum, and he says that he has four main directives. One, safe and trusted products for consumers. Two, continued pressure on the illicit market. Three, retail access and consumer awareness. And four, um, my favorite, easing restrictions on legal operators in a way that doesn't compromise trust and safety in the products. So I think we're hopeful. Clint certainly is, and some of these bills that we just went over hopefully will assist with that. And then next slide we have. So when we're given an outlook here, I think we'll continue to see some refinement of AB 8. I certainly will be monitoring the Schedule 3 move. There's also a lot of discussion around retail access expansion. If that's something you're interested in, shoot me an email because there's a couple different proposals that some of the industry groups are floating around. In the interest of time, I didn't put it on there, but I'm happy to chat offline about it. And then, of course, we have to stabilize the tax situation. So Sacramento, I think, is again focusing on stabilization, not necessarily expansion. And the retail access remains, an issue. And then last thing here I have is just some practice tips for attorneys here. I think again the federal tax planning, looking at 280E is really important. Being proactive instead of reactive to compliance issues so that you don't ultimately have to deal with regulatory enforcement. And then of course, there's a lot of M&A going on. Although not so much from outside investors, which we used to see quite a bit, other states wanting to do business in California. Other states have taken a more common sense approach to their regulations, although no state is perfect. But again, we're starting to see some receiverships as well. And then, of course, understanding those ownership rules is really important. So again, I could talk about any one of these things for hours and hours on end. But unfortunately, my time is up, and I want to make sure that I have time to answer any questions. And if you have to pop off, please do feel free to shoot me an email if you want to discuss any of this further. I'm happy to help.
Okay. I think we have two questions. So the first one is, this has been such a thorough, informative presentation, and they were wondering if there's any regulations covering cannabis festivals, if there are any laws tying cannabis dispensaries to DUI similar to dram shop laws.
Yeah, oh, that's a great question. So there is an events license that you can apply for. It's not overly burdensome to get, but what is tricky is that the places where events are allowed is they are few and far between. But there is an events license, and it's kind of interesting too because that's talking about like events open to the public. Private events becomes an even like more nuanced discussion. But yes, there is an events license. Um, and, I don't, it's my understanding that there aren't necessarily those similar laws in terms of like dram shop because how do we test that, right? Like if I smoked cannabis 4 days ago, I would test positive for cannabis, but I'm not impaired right now. I'm not impaired while I'm driving. So it's tricky, but there was just and I believe it was California Supreme Court, but perhaps I'm wrong. Interesting about loose marijuana in a vehicle and whether that it would trigger a search of probable cause, and actually said no, it doesn't because unlike like a beer you could grab like in a center console and chug chug chug, if you had little like trim, the case arose from someone was pulled over and there was like loose teeny bits of loose cannabis. I mean, like negligible amounts in the car. And ultimately, what the court says is like, that's not the same as a beer that's sitting or a bottle of alcohol, that it has to be to trigger a probable cause, it has to be in an amount that could be usable. So simply having loose, cannabis in the car is no longer grounds for a search. So I thought that was interesting. An interesting advancement in the law. But no, but I'm not familiar with anything that would be akin to dram shop. Again, because how do you test that, right?
Interesting. Okay. Another question said, do these companies usually file as state LLCs and federal form 1065 partnerships or something else? What does the tax return typically look like?
Well, Peter, I'm not a tax attorney and I have no idea what gets filed federally in terms of this 1065, but I don't imagine there's much to file federally because it's not recognized. If you're interested in the tax side, I have a lot of phenomenal tax attorneys and CPAs that I work with. And if you shoot me an email, I would be delighted to put you in contact with them to talk about what those returns look like. I've looked at them as part of like due diligence and deals, but then I also say, and who's your CPA? Because we need to discuss this with them. But you can be, at the state level, an LLC or a C Corp. I would never suggest sole proprietor, but that is similar to any other business. It's a conversation of what your plans are and what structure works best for you. But I don't know about this 1065, but I'm going to Google it when we're done.
Okay, and then one more question is, when do we expect to see proliferation of consumption locations? So like bars that
Yeah.
you can consume
So again,
marijuana at?
that is another wonderful question. There was a bill that passed last year, and I will email you the bill number because or if you email me, actually, I don't have your email. And I can send you that. But it's a local consideration. And so I believe Palm Springs and San Francisco, no, not San Francisco. Yes, maybe San Francisco. Yeah, San Francisco has like smoking lounges, but West Hollywood has a bunch of consumption lounges, and it's a challenge because what those look like isn't necessarily where you're going to order like an infused meal. You can order a meal and then you can purchase maybe a tincture and then you yourself can drop it over your meal. But the ability to purchase like a meal or an infused coffee or something like that, that doesn't exist. You could buy your edible and eat it at the consumption lounge. And I think San Francisco allows smoking, but like smoking lounges, but they don't have this like cafe experience. I think if you're interested in that, I think the Artistry is a really great one in West Hollywood. There are a number of them. But again, that's like a whole other set of regulatory obstacles and burdens that go into that. But again, shoot me an email because I did a presentation on that last year and I can pull some really good stuff from that for you or even just send you the deck.
Awesome. Okay, there is one more question about how you can receive a code for MCLE credit. Once we verify attendance, we'll be sending an email to the email you used to register with your MCLE certificate. Give us some time for that. So if you don't see it today, check your email on Monday, but we will be sending them out to those who have been verified. And then last thing, I just want to say thank you so much to our speaker, Kimberly, for such an interesting and informative presentation. We always enjoy having you every year to do this class. Thank you to everyone who participated today and attended today's class. And just reminder, if you have a couple minutes to fill out that survey, we would greatly appreciate it.
Thank you
Awesome.
so much. I did see that someone popped one more question about Sessions by the Bay, which
Yes.
is
Yeah.
the consumption lounge in San Diego County. Just
Yeah.
shoot me an email. Again, I'm like a policy nerd, so I'm happy to chat about how that came to be and what some of those regulations were. So feel free to reach out. And thank you always to the San Diego Law Library for having me.
Yeah. This was great. Thank you so much, Kimberly.
Thank you.